Harini Law Circle மாணவர்கள் அனைவருக்கும் வணக்கம். I welcome you all back once again to our channel and this is Advocate Frederick. This session is part 14 of our target to complete 50,000 multiple choice questions in law. If you haven't seen our previous 13 parts, I request you to visit our channel's playlist or check out for the links in the description box. These 50,000 questions will help you crack any legal examination which is conducted in your state or in the national level, be it the civil judge exam conducted by Tnpsc, special legal officer exam conducted by various departments in India, judicial services exam, or even the district judge examination, you will have the confidence to put your 100% in your performance. These 50,000 questions are divided into 1,000 parts to make it easy and comfortable for you in your preparation. We have also planned to organize or post videos on mains based descriptive question and answers with explanations, and I'll be teaching you all the 1,000 mains based descriptive questions, so stay tuned to that also. The only favor that I request in return for all these uh, educational content is I want you all to just share this session or our upcoming sessions to your friends, juniors. If there is any teacher or a professor who is watching this session, to your students as well, who are not able to afford for a proper coaching or to join a proper mock test. So in that way, it will be very helpful for the benefit of the entire legal community. So it's a service to the society. And I also want you all to subscribe to the channel so that you also don't miss even a single part of this session and stay updated on all the legal classes. So with that, let's move to the first question of this session. So this session is basically the all the 50 questions in this session is with regard to the Transfer of Property Act. One of our students of our channel requested it in the comment section that subject-wise topics are required for him. So keeping him in mind, I am posting this session, which is completely Transfer of Property Act of 1882. So all the questions in this session will be from the same act. So which of the following does not come under the immovable property as per the Transfer of Property Act 1882? So the questions will be given to you in English and the answers also will be given to you in the next slide with the explanation. And the answer to the question is marked in bold in the same slide itself. So this is practically a session where we are preparing ourselves for the exam. We are not conducting any mock test here. So we are preparing. Instead of using hefty books, keeping it on our table, reading it line by line, using barracks, preparing in it on it. So we are moving into directly into exam based question method. So this is one of the best methods which is widely followed all over India. So which of the following does not come under the immovable property as per the Transfer of Property Act 1882? We all know that right to claim maintenance is an ambiguous line which is mentioned as option B. So right to claim maintenance with respect to transferable property is an immovable. A transferable in the sense with respect to a movable property, there is a right to claim maintenance. Then it does not come under immovable property. But right to claim maintenance as part of an immovable property does not come under immovable property under Transfer of Property Act. Okay. So the answer is sale of a ceiling fan. So pause for a while, read the complete explanation and then move to the next question. Do not be in a hurry to complete the session. It's of no use. You are studying for the exam. You are not wasting your time. You are studying for the exam. Keep that in mind. Second question. According to the Transfer of Property Act 1882, the term immovable property does not include land, mines, agricultural land, growing crops. So the term immovable property includes land, mines, and agricultural land. It does not include growing. So Section 3 of Transfer of Property Act 1882 states that the Act does not give an exhaustive definition of immovable property, but it clearly says immovable property does not include standing timber, growing crops, or grass. So these three things are not included as part of immovable property. The General Clauses Act of 1897 also defines an immovable property under Section 3, subsection 26, as which includes land, benefits arising out of that land, and things which are attached to the earth or permanently fastened to anything attached to the earth. So, as we can see from the explanation that growing crops are not part of an immovable property. Moving ahead to the third question. Under the Transfer of Property Act 1882, the term attached to the earth does not mean trees, shrubs, growing crops, walls, or buildings. So we all know that trees are attached to the earth, shrubs are attached to the earth, growing crops are basically, in general terms, attached to the earth. Yes, walls or buildings, of course, yes, they are attached to the earth. But which one of the following, according to the Transfer of Property Act, mean that it does not mean that it is attached to the earth? So the answer is growing crops. Because immovable property differs from the general rule. So immovable property, basically the Transfer of Property Act, the term, it defines immovable property under Section 3, where it says that growing crops are not part of immovable property. And the General Clauses Act of 1897, under its sections and subsection 26, it says anything which is attached to the earth is an immovable property. And the transfer of property says growing crops are not immovable property. So basically, reading these two provisions together, we should have to come to the conclusion that growing crops are not things which are attached to the earth. Okay, next one. Which of the following is not an actionable claim under the Transfer of Property Act 1882? Lottery tickets, beneficial interest in movable property, which is in possession of claimant, life insurance policy, claim for arrears of rent. So, option B is our correct answer. Lottery tickets are actionable claims. Life insurance policies are also actionable claims. Claim for arrears of rent are also actionable claims. But beneficial interests in movable property, which is in possession of the claimant, are not an actionable claim under the Transfer of Property Act. So why is it not an actionable claim? Because the property is already with the claimant, so it is in the possession of the claimant. An actionable claim requires the property to be in a possession of somebody else and not that of the claimant. The claimant should not have the possession. Somebody else should have the possession, and there should be an actionable claim. Actionable claim is a legal right of action. Okay, so you go to the court and file a petition of plaint. Then such a legal right to go to the court and sue for your case is the actionable claim that requires you to demand back the property. But the possession of the property is with you, right? Why do you have to go for an actionable claim? So such things are not actionable claims. Moving ahead to the fifth question. Which one of the following is not an actionable claim? So the options are not clearly framed. I just want you all to skip this question and move away to the next question. And I will discuss this question in the upcoming sessions. Okay. Don't worry about this question. I'll discuss the same question in the upcoming session with the clear options. Sixth question. Which of the following would be considered as transfer of property under the Transfer of Property Act 1882? Select the answer using the code below. Grant of an easementary right of way over a piece of land. Exchange of two things, a family settlement, creation of charge on an immovable property by operation of law. So granting easementary rights of way over a piece of land. Easementary right is the right of way. See, a land is there and there is a way in which one has to go by the land. For example, there are two people, A and B. B's land is in between A's land. So A's land is surrounded by B's land is surrounded by A's land, and now B has to get into his land, right? So for the same purpose, a right to pathway is being given to B. So this right is known as easementary right, the right to way which is available to a person who does not have a pathway to his residence for the complete and fulfilled enjoyment of his property. He needs to have that easementary right. So grant of an easementary right of way over a piece of land is not a transfer. Nobody is going to transfer an easementary right to you. Easementary right is the right which is available to you in case you need to enjoy the property as provided by law. So it is the right inherent to you. Nobody is going to transfer that right to you. Okay, you cannot grant that right. So it is not transfer of property. Second one, exchange of two things. Of course, you exchange something to another person. Then there is a transfer, right? Okay, second one. So two is the correct answer. Third point, a family settlement. Family settlements they come under succession of property and various other laws which govern the transfer of property with regard to personal family laws. They do not come under Transfer of Property Act. And fourth one, creation of charge on an immovable property by operation of law. For example, if there is a rent, dividend, or any other charges like maintenance which arise out of a immovable property and you have a claim on that, and such claims or such charges are transferred to some other person, so in such cases that would amount to transfer of property, right? So option 2 and 4 are correct. Option D is the right answer. Next one, seventh question, what does the rule of pest successiousness mean? Pest successiousness means once a mortgage, always a mortgage. Mere right of re-entry for breach of condition subsequent cannot be transferred. The chance of an heir apparent succeeding to an estate cannot be transferred. Transfer to unborn child is not valid. So the correct option is, as you can see in the screen, the chance of an heir apparent succeeding to an estate cannot be transferred. So what does the term speciousness mean in a general terms is that it means hope of succession. So the mere possibility or the expectation of inheriting property in the future of the sons of the person who is deceased, right? So a person dies, and obviously there is a possibility, there is an exception, there is an expectation from the heirs of that person who is being deceased that the property after him would come upon us. So such kind of expectation or the hope of succession is known as pest successionist. Okay. So the key principle which is involved in this particular Latin maxim is that a person cannot transfer a mere expectation of inheritance because it is not a present property right. So there is only vested rights in it. So it cannot be transferred. See, I have a hope that my father has some property and when he dies, the property will come up to me. So I cannot transfer the hope which I have to one of my friend, right? See, there is a friend of mine and my father has some property. After he dies, for example, after he dies, if I hope so that property will come to me, then that is a hope of succession. But I cannot transfer my hope to my friend that after my father dies, you will get the property. Can he think like that? He cannot think like that, right? So there cannot be transfer of such a kind of thing. So that is what this principle says all about. Eighth question. Chance of an heir apparent succeeding to an estate cannot be transferred. Which provision of the Transfer of Property Act 1882 states this? Chance of an heir apparent succeeding to an estate cannot be transferred. Which provision of the Transfer of Property Act 1882 states this? So this is a repeatedly asked question. So just keep this question in your mind. So section 6 deals with the same. So what it says is that certain interests in property are not transferable. Which of the following are not transferable though having certain interest? Subsection D of section 6 specifically states that a mere expectancy or a chance of succession, that is what I told you in the previous question, hope of succession, they cannot be transferred. So particularly the act under section 6 distinguishes between two things: transferable interests and non-transferable interests. Transferable interests are those which are regarding the present property rights which an individual has, and the vested interest which the particular person who claim a right to the property, the actionable claimed person, the claimant, has on the said property, the vested interest or the present property right. He might have ownership, possession, or patta in his name, or a registered sale deed in his name. So, in certain conditions, with certain conditions, he might have the present property rights, or he might have the vested interest, like hope of succession. So, such things are known as transferable interests. Non-transferable interests are mere expectations or chances of inheritance or future contingencies. Future contingencies means on the happening of an uncertain event, such thoughts of transfer. See, there are three people, A, B, and C, and A says to B that on the death of C, my property will be given to B. So A says, I will give you a property, I will give my property to you, that is B, on the death of C. So C dying is an uncertain event. Before C dies, there are chances that A or B might die. It is based on an uncertain future contingency. Okay. So on such cases, such kind of interest cannot be transferred. Next one. As per the Transfer of Property Act 1882, which of the following is not transferable? Future property, it is transferable. Movable property is transferable. Immovable property is also transferable. Pension amount of the pensioner. A pensioner who is receiving pension, he might receive his pension for old age, or he might receive a pension out of retirement. So, on such cases, the pension amount cannot be transferred to another person who is not qualified to receive the same. Next one. Which of the following property cannot be transferred under the Transfer of Property Act 1882? A public office, a mere chance to succeed, a mere right to re-entry, all of them. So the correct answer is all of the above. So a public office cannot be transferred, a mere chance to succeed cannot be transferred, a mere right to re-entry also cannot be transferred. See, I'm giving you all of the above as an option means there are many chances that any one of the above, A, B, or C, any one of the above might come as a single option in your options. They might ask public office among options which can be transferred. So you need to choose public office that cannot be transferred under the TP Act. And a mere right or a mere chance to succeed is also a thing which cannot be transferred. They might ask it as one of the options, and the other options might be transferred. So you have to read all the three things and then remember it. So section 6 of Transfer of Property Act, I have already dealt with the same. So moving ahead to the 11th question. The land for the beneficial enjoyment of which an easement exists is called. The land for the beneficial enjoyment of which an easement exists is called. Servient heritage, dominant heritage, extinct heritage, none of the above. Dominant heritage. Option B is the correct answer. So we need to know what is dominant heritage, right? So the Easements Act, section 4 of TPA defines an easement. An easement is a right acquired over one land, which is a serving heritage. Acquiring right over one land is known as serving heritage for the benefit of another land, that is the dominant heritage. So, a person A surrounds B's land. So, A's land is surrounding B's land. So, the right which A has is known as the servient heritage. Okay. And the right which B has is known as the dominant heritage. So, the benefit of another land. Okay. For the benefit of B's land, A is giving away. He is not giving away the dominant right, the heritage oriented right which B already has as a part of easement is known as the easementary right. Do you get the point? So the person A who surrounds B's land is known as servient heritage, and the right which is there within A's land is known as the servient heritage, and the right which B holds as a benefit of another's land is known as the dominant. I think now you understand. Next one. Transfer of property is not applicable to gift of movable property, exchange, lease, sale of goods. So you can transfer gifts, you can transfer, you can exchange, right? We have already seen exchange of two things amounts to transfer. So we can exchange things, we can gift things of movable property, we can lease things, we can lease out things. But sale of goods, transfer of property is not applicable. So sale of a property through a transfer is applicable, but sale of goods are not applicable. They cover under Sale of Goods Act, not under Transfer of Property Act. Next one. In which section of the Transfer of Property Act 1882 has the rule against perpetuity been mentioned? So the rule against perpetuity is being mentioned in section 14. We have already seen in our previous sessions regarding the same question, the principle of perpetuity, where section 14 says that no transfer of property shall be valid if it suspends the absolute ownership of property for an unreasonable period beyond lives in being plus 18 years. So the objective of this provision is to prevent property from being tied up indefinitely, and it ensures alienability. I have given you an illustration here. I just want you to read the illustration so you will understand it very well. The rule against perpetuity under the Transfer of Property Act is applicable to which among the following? So section 14 of Transfer of Property Act is applicable to both movable and immovable properties. So it is not restricted to any one of the property. It is applicable to both the properties. 15. Which section creates exception to the restrictions in section 14, 16 and 17 of the Transfer of Property Act 1880? So which section creates exception to the restrictions in section 14, 16 and 17 of the Transfer of Property Act? So the correct answer is 18. So the exception is 18. So what does section 14, 16 and 17 say, and what are the exceptions are dealt here in the explanation? So basically section 18 deals about transfer for benefit of public. So there are certain restrictions with regard to section 14, 16 and 17 that which do not apply where the property is transferred for the benefit of the public. For example, if there is a transfer for the advancement of some religion, section 14, 16 or 17 do not apply. If there is a library which is being built in a land and there is a demand for certain property in a particular area within the city, then such transfers do not apply. Advancement of health, building up of hospitals, building up of commercial zone like SIPCOT, TITCO, it all comes under commerce. and advancement of safety or other objects which are beneficial to mankind. So for these purposes, if there is a requirement from the state for the transfer, you cannot say that section 14, 16 or 17 has some restrictions with regard to transfer and I cannot do so. They do not apply. They are exceptions. Okay. Next one. 16. A transfer of property by an ostensible owner. So ostensible owners are Benami transactions, right? Ostensible ownership, where the possession of the property would be there with him, but he does not have the legal claim of the property. He is not the proper owner of the property, but the possession is with him. And he shows to the society that he is the owner. He symbolically represents that he is the owner, but he is not the owner. So the transfer of property by an ostensible owner shall not be voidable provided the transferee acted in good faith. So this is an exception. So basically, if it is not through good faith, then it would have been void. But the transferee, if he had acted in good faith, ostensible ownership transfers are not voidable. So this is the exception which is mentioned in section 41. Next one. Section 43 of the Transfer of Property Act 1882, which deals with transfer by an unauthorized person who subsequently acquires interest in a movable property transferred, underlines the doctrine. So which doctrine is applied in the above situation? So an unauthorized person transfers a property who then subsequently acquires the interest in the immovable property which is already transferred. So estoppel by deed. So what is known as estoppel by deed? Wherein a person, for example, A has agreed and transferred to B certain property which he says he owns, Based on the transferee's good faith on A, B acquires the property in documents through deeds. But later on, it is found to be known that A did not have the property at the time of the transfer and A acquired the property only later on. So in such circumstances, A cannot say that the transfer which I effected previously before I had the property in my ownership is null and void. He cannot say that. The law says he is debarred from saying so, and it is the right which is available to the transferee, that is the person who acquired the property through the sale or any other mode, to hold the property and claim the property. So this is what the concept says. So transfer by an unauthorized person who subsequently acquires interest in the immovable property transferred. So this situation is applicable in the case of option B, estoppel by deed. So this is mentioned in section 43. So KK Verma versus Union of India is a landmark decision based on estoppel by deed. Next one. The doctrine of lis pendens is given under which section of the Transfer of Property Act? So the correct answer is 52, section 52. So what does section 53 state? Section 53 deals with fraudulent transfers. Section 53A deals with part performance. Section 41 deals with ostensible ownership as an exception, and in what cases a property can be transferred. So what is the doctrine of lis pendens? So basically this doctrine is known as, in general terms we call it as pending suit or litigation which is pending. So during the pendency of a suit or proceeding relating to an immovable property, any transfer of such property by the parties to the suit is subject to the outcome of the suit. Okay. During a pendency of a suit, in case you transfer some property, such transfers are based purely on the outcome of the suit, and the transfer may be valid, void or voidable based upon the proceedings of the suit. on the disposal of the suit. Okay. So it applies only in case of movable, immovable properties. It does not apply to movable properties. It then protects the interests of the parties who are not involved in the transfer, and it also ensures that a transferee cannot defeat the claim of the plaintiff or defendant in the ongoing suit. So here is an illustration given to you. Read it to get better clarity on what list pendants is. So Sundarlal was a state of UP is a landmark district. Next one, statement A, statement B, wherein we need to find out which of the following codes are right. Statement A says that every transfer of immovable property made with an intent to defeat or delay the creditors of the transferor is void. Every transfer of immovable property made without consideration with intent to defraud a subsequent transferee is void. Obviously, so any transaction without consideration itself is void, first of all, and there is an intent to defraud the transferee is obviously void. The second statement is correct. Statement A is every transfer of immovable property made with an intent to defeat or delay the creditors. So there is a malintention, right? A malified intention to defeat or delay the creditor. So such kind of transfers of immovable property are also void. So both the statements are correct. So read the explanation to get to know the sections. So section 53 and 53A deals about the same. Fraudulent transfers, right? 53 deals about fraudulent transfers and 53A deals about part performance of a contract of sale. Question number 20. Which of the following cases decided by the Privy Council relates to fraudulent transfer? Musahar Sahu versus Hakim Lal. So let's look at the case. So in this case, it is concerned with transfer of property by a debtor who was a creditor of the appellant. So the question was whether the transfer was made with the intent to defeat or delay the creditor. So there was an intent to defraud the creditors. So it was held as a fraudulent transfer under Section 53 of Transfer of Property Act. And I have also given you the other case laws with respect to which of the following doctrines. So just have a go through of that too. 21. What does Section 53A of the Transfer of Property Act 1882 deal with? I have repeatedly told you 53A deals with part performance. So why I am repeating the same questions, or why do I repeat the same topics, is that only when we revise, we won't forget anything. See, the examiners, they don't set up questions from an unknown world. They set up questions within the law. So there are only few provisions that has a wide importance and where questions can be framed. Basically, you cannot frame questions in each and every section of any law. So multiple choice questions can be framed only in few cases. We cannot frame at all. The only way to frame questions in all sections is giving you the headline and asking you the section. That can't be done in all the questions. Do you get the point? So it is only based upon the explanation, the content, the intricate difficulties with the section that questions are framed. So these are most important questions which needs to be revised again and again. So I'm not compromising on that part. Moving ahead to question number 22. Section 54 of the Transfer of Property Act 1882 deals with sale of an immovable property. So now you can see that we have dealt with section 52, which is list pendants, section 53, which is fraudulent transfers, 53A, which is part performance, now 54. We are not going to leave any section. We are going to cover each and every section. We are not going to leave any section, but the way we cover matters. So in a particular section, if I repeatedly go ahead with a particular set of sections, you would not forget that section for your life. It is not that you are going to write your exam, then forget everything after you become a judge. You need to remember each and every section when you go and sit on that bench. If you forget things, then even advocates, they won't respect you basically. They're not going to respect you in case you don't know the sections and the provisions and the concept before you go as a judge. So section 54 deals with sale. So what does it say is a transfer of ownership in exchange of a price for a price paid or promised is a sale. So only immovable properties other than actionable claims can be sold under this section. So the point you need to remember is section 54, sale, price or promise, immovable property. So these are the key terms. So there is a transfer of ownership in exchange for a price. So the price or promise is the consideration, right? So transfer plus ownership plus consideration plus immovable property. So these are the four things which you need to remember in case of section 54. Next question. Every sale accompanied by agreement for reconveyance of property would not constitute mortgage by conditional sale. So section 58 is also a common question that arises, and we have already dealt with this section in our previous parts in detail also. Now 58 is also covered. So mortgage by conditional sale. This is with respect to the mortgagee's right to forfeiture, which is also included as part of section 58. So the mortgagee has the right of forfeiture and the mortgager has the right of redemption. Don't get confused in case the examiner will obviously try to confuse you with these points. The mortgagee has the right to foreclosure, and the mortgager has the right to redemption. And section 58 defines different types of mortgages, including mortgage by conditional sale. And the right of the mortgagee for foreclosure is with respect to mortgage by conditional sale only. So this is also another question which is usually asked. The right of a mortgagee for foreclosure to foreclosure is with respect to which of the following types of mortgages? Simple mortgage, usufructory mortgage, English mortgage, or mortgage by conditional sale. So the answer will be mortgage by conditional sale. See, you need to understand the concept entirely, then only you will be able to apply it in the exam. It won't take even 2-3 seconds to read the question and answer. But if you don't know the answer at all, even if you think for 1 minute, you're going to go wrong. Only on probable basis, you might get it correct, but otherwise you'll go wrong. So conceptually understand things and then start preparing. So our session is not just a session where we complete all the 50 questions, throw away the slides and then move to the next slide. That is not the way we are going to cover these 50,000 questions. See, 50,000 questions, to say so is very simple, but covering all those questions is very complicated. It has been almost 15 days, but still we are in part 14 only. And to complete 1,000 parts, it will be like, it will take a time, it will take some time. You need to study for that time. This process is basically to make you study, even though if you don't feel like studying, taking 1 hour a day will help you within 1.5 years. You will be able to complete all these 50,000 questions along with your mains questions. Take some time, start preparing every day. Don't go for the last minute. See, I'll prepare after the notification. Let the notification arrive. I have 3 months to prepare. Obviously, guys, you can prepare in 3 months, but the way you are preparing matters. So you can prepare in 3 months all these 50,000 questions by preparing at least for around 10 to 12 hours a day. Okay, not by preparing 1 hour a day. But you have to also concentrate on your own course of work. You might be working somewhere, you might be going to college if you are a final year student, or you might be a junior to a senior advocate where you need to prepare on drafts and other matters. So you might not have much time in preparing. And after this new rule, obviously final year students are not going to prepare for these examinations immediately. They have 3 years time. So all the students who prepare for civil judge exam or judicial services exam will have to serve those 3 years
So during these 3 years, I request you to prepare on these content where you will have a clarity on the entire syllabus. So you will not fail in the exam. That I will ensure. Next question. In which of the following mortgages is the mortgagor required to deliver possession of the mortgaged property to the mortgagee? So it is usufructory mortgage. See, usufructory, don't get confused with words. If you know the concept, words doesn't matter at all. Usufructory mortgages are mortgages where you will have the possession of the property, and the rent and dividends or any other maintenance that accrue from the property will be held with somebody else. Do you get it? So the ownership is with someone, and the rents and profits which accrue will be with the person who possesses it. Right? A person who possesses the property will rent it out and get the property, but you might have mortgaged that property to the mortgagee, and that mortgagee gets all those benefits, but you don't get the benefit. So that is the usufructory right which the mortgagee has when a property is mortgaged. So section 58 defines an usufructory mortgage also, where a mortgage is in which the mortgagor delivers possession of the immovable property to the mortgagee. The mortgagee is entitled to retain possession and receive rents, profits, or produce from the property as a security for the debt. So there is a question which arises, sir, once after the mortgagor redeems the property, does the mortgagee give back all those benefits which arise out of the property? And the question to this is no. The mortgagee does not return back the benefits which arise out of the property once it is mortgaged. He retains the possession, he receives the rents, profits, and the produce. If it is agricultural property, he utilizes itself for his own benefit as a security for the debt, and he does not transfer the such benefits. Next one. In which of the following mortgages does the mortgagor bind himself personally to pay the mortgage money? So personally binding is simple mortgage. So there is no insurance involved. There is no mortgage there is no principle of indemnity involved. There is no principle of contingency involved. It is just a simple mortgage that the mortgagor, on giving a security for the mortgage, binds himself personally to pay the money. In case of default, the security will be forfeited. Next one. A person in lieu of debt from B. So A gets a debt from B. A gets a loan from B. Okay. Handovers possession of his house to B. So in lieu of the loan, for the loan he received from B, A gives the possession of A's house to B. And there is a covenant to the transfer. So covenant means there is a condition through a contract between A and B. But the provision with provision for retransfer in case of repayment of debt. So the covenant is that on the repayment of the amount which he has got through loan, there needs to be a retransfer of the property by B to A again. Okay, so this type of mortgage is known as English mortgage. Next one. Which of the following mortgages can be made without writing? Without writing. Equitable mortgages. So equitable mortgage means I receive 20 lakhs of money from someone and I give to another person through a transfer 20 lakhs worth of some property of mine. So in such cases, I don't need to have to execute a written mortgage. So I can do an unwritten mortgage also. So it is known as equitable mortgage. Next one. The mortgagor binds himself to repay the mortgage money on a certain date and transfers the mortgage property absolutely to the mortgagee. with the condition that upon repayment of the mortgage money, the mortgagee will retransfer it to the mortgage. See, this is the same type which we saw in the previous question, number 26. As you can see, this particular explanation applies there to question number 28 also. So there is no much difference. Only the explanation to the line changes. There we have mentioned A, B. Here we have mentioned mortgagee, mortgagee. So that is the thing which changes. So I have made it a point that I want you to read both the type of sentences, because there are chances the examiner might ask uh, with mortgager and mortgagee, or he might choose A and B. So it is upon the examiner to decide on what terms the questions could be set. Next one. In which of the following cases did the Supreme Court recognize the principle once a mortgage, always a mortgage? So the cases: Mrityunjay Pani versus Narmada Bake Kasumal. So the case law, reading case laws is really difficult when there are names which come like this, obviously. So it is Mrityunjay Pani versus Narmada Bake Kasumal. Once a mortgage, always a mortgage. So the principle says that the mortgageor's right to redeem the mortgage cannot be extinguished merely because of the mortgagee acquiring the property. So the mortgage continues to exist until redeemed, merged, or terminated by law or order of court. So there is an exception to this particular once a mortgage, always a mortgage doctrine. So that is mortgage by conditional sale. So in case of a mortgage by conditional sale, this doctrine does not apply. So this is another point that I tell you out of the legal explanations. Next question. A suit to obtain decree under section 67 of the Transfer of Property Act 1882 is called suit for foreclosure or sale. As I already told you, the mortgagee has a right to foreclose, right? So this right of foreclosure is available under section 67. Next one. Which of the following statements is incorrect under the Transfer of Property Act 1882? Right of redemption belongs to the mortgager. So they are asking the incorrect one. Right of redemption belongs to the mortgager. Yes, the mortgager has the right to redeem the property which is mortgaged. First one is right. Right of foreclosure belongs to the mortgager. No. Right of foreclosure under section 67 of Transfer of Property Act belongs to the mortgagee. Right of redemption can be abrogated. Of course, it can be abrogated. Right of foreclosure can be abrogated. Obviously, it is true. So option B is the correct answer. Next one. A mortgages a certain plot of building land to B, and afterwards erects a house on a plot for the purpose of security, for his security. B is entitled to the house as well as the plot. A, when giving the property as a security to B, he gave only the land. But afterwards, B erects for his own purpose to keep a security. Then such house and the plot both belong to B once the repayment is done. On the repayment, B has to give both the house and the plot. He cannot withhold or demand for the plot, for the land, for the house. Okay. Next one. From the following, who cannot sue for redemption of the mortgaged property? So, who cannot sue for redemption? So, the mortgager has the right of redemption. A is right. Mortgagee has the right of foreclosure, not of redemption. So, mortgagee cannot sue for redemption. Next one. Next one. Transfer of right to enjoy an immobile property is consideration of a price is known as lease. You transfer to enjoy an immobile property to some other person. You transfer the right to enjoy. See, I hold a property, I give it to you, and you enjoy it, and I take a price out of it. So such kind of transfers are known as lease. It is not a license, actionable claim, or a mortgage. It is a lease. So this is mentioned in section 105. Next one. In view of section 105 of the Transfer of Property Act, a lease of immovable property is a transfer of. So the question is absolutely reversed. So 34th question is absolutely reversed because it is upon the examiner's mindset on how he frames the question. So I think I get into the minds of the examiner and then frame the questions. So that is the reason questions repeat, but you have to study on this aspect. A right to enjoy such property in consideration of a price paid or promised, or of money, share of crops, service, or any other thing of value. So the additional point that you get from this question is it can be price paid, it can be promised money, it can be a share of crop, it can be any service or any other thing which is of value, which can be transferred for the right of enjoyment of a property under section 106 in case of a lease. For the lease of immovable property, if the tenure is more than 1 year or year to year, what is the necessity? So the attestation of a notary is sufficient. It is valid if the execution of it is made before the magistrate only. It is sufficient if the parties make an agreement. Only registration is sufficient. So it is only through an amendment that this answer came. So in case a lease of immovable property is more than a year or year to year, it is only through registration a lease can be done. Next one. A lease of immovable property for any term exceeding 1 year can be only by a registered instrument. So the same question, but through different framing. Next one. The amendment of the Transfer of Property Act 1882 in the year 2002 amended the provisions of section 106. So section 106 is with respect to leases of immovable property which are exceeding 1 year. Next one. Which one of the following is not a kind of agricultural lease? Cultivating indigo, cultivating vegetables, rearing of tea plants, all these are agricultural leases, but gathering fruits from trees are not agricultural leases. So there needs to be something which grows from it. Just gathering fruits from trees already there does not amount to agricultural lease. Next one. A lessee accepts from the lessor. So lessee is the person who acquires the property and enjoys it, and the lessor is the one who has the ownership of the property. So a lessee accepts from the lessor a new lease of the property lease to take effect during the continuance of the existing lease. So this is an implied surrender of the former lease. So once this new lease takes into effect on the continuance of an existing lease, so it implies that the former lease is surrendered to him and a new lease is formed. So no two leases can subsequently be effectuated at the same time. Next one. Where the time limit of a lease of a year, of number of years, which is expressed to be determinable before its expiration, and the lease omits to mention at whose option it is so terminable, who shall have such option? Let's reread the question. Where the time limit of a lease is of a year or number of years, which is expressed to be determinable before its expiration, and the lease omits to mention at whose option it is so terminable, who shall have such option? So the lessee shall have the option to terminate the lease at his own option before the expiry of such lease. The lessor cannot say that you need to stay back in the same property and pay me a price or give me your share in crops. He cannot say that. The lessee has the right to terminate the lease before the expiration of the previous lease. So this is mentioned in section 110 of the Transfer of Property Act. Next one. Ashok lets a house to Bharat for 5 years. Now Bharat underlets the house to Kishore at a monthly rent of 2000. The 5 years expires, but Kishore continues in possession of the house and pays the rent to Ashok. What is the status of Kishore? In other terms, let's reframe the question. A lets a B to A lets a house to B, and B in turn underlets the house to C. After the expiry of that 5 years, C continues in possession and pays the rent to A. So what is the status of Kishore? That is C. So he is a tenant holding over. Even after the expiry of the term, if he pays the rent to the initial owner, then it is known as tenant holding over. So it is mentioned in section 111. When a lease expires, the tenant continues to remain in the possession with the consent of the landlord, explicitly or impliedly. It is called as tenant holding over. Next one. A lessor gives notice to quit the property leased. The notice expires and B remains in possession. A gives B a second notice to quit. Then what happens to the first notice? What happens to the second notice? Or are both the notices effective, or only the second notice is effective is the question. Now both the notice will be effective. So the first notice is also effective and the second notice is also effective. So once the second notice is given, we cannot take a stand that the first notice does not operate. Next one. So I have given you a clear flow chart of what will happen in this particular case, where the start of the issue starts from lease period ends or lessor wants termination. Now lessor issues first notice to quit the house and the tenant receives notice. Now the tenant vacates, yes, no. If the tenant vacates, then the lease is terminated, and if the tenant does not vacate on the first notice, the tenant remains in possession, right? And the first notice expires and lessor issues second notice, tenant receives a second notice, tenant vacates, then the lease is terminated, and if he does not vacate, then the tenant is still in possession and the legal action for eviction comes, right? Once the legal action comes, what documents do we submit to the court? We submit both the notices, right? So we submit both the notices to the court to take legal action. So after the expiry of the first notice, on legal action, both the notices are valid. The notices expire, but for legal action, the notices are valid. Next one. Which of the following statements regarding gift under the Transfer of Property Act 1882 is correct? So gift is the transfer of certain future movable or immovable property made voluntarily and without consideration. Yes, it is correct. Let's reread it whether it is correct. Gift is the transfer of certain future movable or immovable property made voluntarily and without consideration. No, it is wrong, right? So it is wrong. Second one, transferor is known as donee and transferee is known as donor in gift. Again, a wrong one. The transferee is the person who receives the gift. So he is known as the donee, and the transferor is the person who gifts it. So he is known as the donor. You donate something to someone, that you are the transferor. Then you donate it, then you are called as the donor, right? You are not called as the donee. The person who receives the gift is known as the donee, the transferee. So B is also wrong. Third one, if the donee dies before acceptance, the gift is void. Obviously, you donate something to a child and the child, before gifting, the child dies. Then to whom are you gifting? So the gift itself is void. C is the correct answer. So C is the correct answer. Option A, B are wrong. C is none of the above. You don't need to care about it. Which of the following is not an essential element of a gift under the Transfer of Property Act 1882? Not an essential element of a gift. Donor and donee in gift, donor and donee are the people who are the transferor and the transferee, right? They need to be there. They are elements of a gift. Subject matter, of course, the subject matter of the gift is necessary. Transfer of the subject matter is necessary. Transfer must be for consideration. In gift, there is no consideration. Gift is just gift. You gift it to someone, you donate to someone. There is no nothing. There is no promise or there is no price paid for the gift, right? You donate it where there is consideration. Next one. Under the Transfer of Property Act 1882, if the donor dies before acceptance of the gift by the donee, what is the status of the gift? So now the question is different. The donor dies before acceptance by the donee. Again, the gift is void. See, the donee dies before receiving the gift is void. If the donor dies before the acceptance of the gift by the donee, the gift is void. Let's take, for example, I'm the donor and you are the donee, and I gift something to you. And before you accept the gift, I die. What will happen? You reject the gift, then what will happen? The gift might go to some other person whom I don't want to give it. So the gift is void. So that remains as part of my property, and it will be transferred according to the succession. Next one. So this is dealt under section 126. Which section in the Transfer of Property Act 1882 deals with universal donee? Very, very important. Very important. Section 128. It deals with universal donee. So universal donee is a person who accepts a gift of the entire property of the donor, or a gift which confers on him all the donor's property. Such a donee is treated like a donor in relation to all properties, meaning he steps into the donor's shoes and can exercise rights and responsibilities as if he were the donor. I hope you understood what the explanation says. I don't need to re-explain it. 48. Which of the following statements regarding Chapter 8 of the Transfer of Property Act 1882 relating to transfer of actionable claim is incorrect? So this chapter doesn't apply to any mercantile document of title of goods. Yes, it does not apply. The transferee of actionable claim, that is the person who receives and he goes for a legal right, shall take it subject to all liabilities and equities to which the transferor was subject in respect thereof at the date of transfer. It's also right, correct one. Every notice of transfer of an actionable claim shall be in writing. So transfers of an actionable claim shall be in writing. Of course, it should be in writing. So the first one is not correct. This chapter applies to instruments which are of for a time being by law or custom negotiable. It is not through custom. Next one. Which of the following statements regarding transfer of actionable claims under Transfer of Property Act 1882 is correct? Transfer of actionable claim is not permissible. Transfer of actionable claim can be made orally. Transfer of actionable claim can be made without consideration. So all the three are wrong. Transfer of actionable claim are permissible. Transfer of actionable claim can be made both orally and written. Transfer of actionable claim can be made with consideration. It should be made with consideration. Without consideration, there cannot be a transfer of actionable claim. So the correct answer is option B. So 50th question, a very lengthy case analysis. So these kinds of questions are also sometimes asked. So I want you to have a practice of such questions. So that is the reason I have framed it. A executes an unregistered agreement for the sale of his immovable property to B for a consideration of 50 lakhs. B pays a substantial part of the purchase money and is immediately put into possession. Before B can complete the sale and register the conveyance deed, C files a suit against A, challenging A's title to the property. While this suit is pending, A, knowing about the suit but disregarding B's possession, executes a registered gift deed of the same property in favor of his nephew D. Without any consideration, D, armed with the registered deed, attempts to dispossess B. So, which of the following statements best describe legal possession of B and D? So, to understand this, you need to know or have knowledge, in-depth knowledge of the doctrine of lispendence, what is part performance, what is gift. So, these are the major important parts that you need to know before applying this particular case. So let's move to the explanation. Let's not go into the answer right now. It might confuse you. So here, understanding part performance is so this doctrine under section 53A, as I have already explained to you in the previous questions also. So it protects a person in possession of immovable property under an agreement for sale, where a substantial part of the consideration is paid. So here in this question, this substantial part of consideration is paid. So a part performance is done. So now you have only a right to defense and you cannot claim it as a legal right, as an actionable claim. So keep that in mind. Next one. Doctrine of lispendence, where it protects the right of parties when a suit is pending in another court. You cannot transfer property during a pending suit. But what happens is there is a transfer of the property when the suit is pending. So it does not defeat B's possession, right? Okay, next one. Analysis of facts. B has possession, paid a substantial part of consideration under part performance, section 53A. It is an unregistered agreement which is protected under section 53A now. So section 53A is a exception to the normal general rule. Then now D has a registered gift but no consideration. Cannot defeats B's equitable right. So therefore B can continue possession. D cannot dispossess it. So option C is the correct answer. Moving to the homework question of this session. Which part of the Indian Constitution contains the fundamental rights guaranteed to the citizens? I hope on reading it, you'd be able to answer it directly. No confusions. Yes, very easy question. So that with that I end part 14 of our 1000 series of questions, and see you in the next interactive session of part 15. Till then, stay tuned to our other sessions of this particular part and take care.